always know what's best for us. Sometimes we simply have to trust someone else to act in our best interest. The law recognizes some of these trust-based relationships such as the one between a doctor and a patient, or a lawyer and their client, relationships that are fiduciary in nature. Such relationships typically involve a power differential between the parties. For instance, a patient often doesn't understand all the details of a treatment, but trusts the doctor regardless to do what is best for him. The law helps build this trust by stopping a fiduciary from taking advantage of the power dynamic. It mandates that a fiduciary's most important duties are loyalty and care. This ensures that a fiduciary always acts in the best interests of the beneficiary. Such protection is missing in today's digital economy, where technology can significantly influence our decision-making. The laws dealing with contracts and consumer protection simply don't safeguard our personal data well enough. The Personal Data Protection Bill 2019 tries to fix this by using the fiduciary framework to try and protect personal data. Under such a framework, digital service providers such as Facebook, Amazon, and Google should, in theory, be required to process your data for your benefit. This essentially would make them data fiduciaries. But have the high standards of loyalty and care, which generally apply to a fiduciary relationship, been implemented under the draft data protection law? And would the fiduciary framing really work for this purpose? While the law does put in place measures to ensure that service providers act in accordance with the expectation of users, data fiduciaries will have to provide adequate and material disclosure of their online data processing practices. Data fiduciaries must also take reasonable steps to ensure that users' personal data is stored securely and not given to third parties without users' consent. However, the business models of most data processing entities monetize user data in exchange for free services. A true fiduciary structure of data protection would ask whether this is in the best interests of the user. The Personal Data Protection Bill, however, only uses the phrase "such as standard" in the context of children's data. For all other individuals, service providers are only required to act in a manner that is bona fide, diligent, and reasonable. This standard is similar to that currently expected of insurance providers. The bill, therefore, continues to place the onus on the user to take charge of their personal information. Users will still have to read and understand privacy policies before giving their consent to a data controller. This can be problematic in India, where the levels of literacy and technological awareness are generally low. This also detracts from the fiduciary nature of the relationship, where the more powerful party is supposed to look out for the interests of the weaker one. Overall, the Personal Data Protection Bill does not apply the fiduciary concept to the greatest possible extent. The rights and obligations laid out by the bill are similar to those in the European General Data Protection Regulation (GDPR), which does not attempt to use the fiduciary concept at all. In other words, the same ends could have been met without using the fiduciary framework to begin with.